King on the application of Kone and the Home Department.
Well, good morning, my lords, and may it please you.
Yes, Mr. Biggs.
Good morning. So, as you know, I appear on behalf of the appellant. My learned friend, Mr. Patrick Lewis, appears on behalf of the respondent.
Yes.
A couple of points of housekeeping. There's a supplementary skeleton argument from us. I understand that my learned friend does not object to that being considered by the court, but I'm conscious it's strictly...
Sure that I've seen that.
I don't think I've seen it either.
Supplementary skeleton. We had some additional authorities which came in yesterday. Not sure I've seen a supplementary skeleton.
Very well. It should have been e-filed last week and filed in hard copy. I think we've got hard copies available.
But if it was filed last week, when the hearing was due weeks ago, to any chance that it wasn't dealt with weeks ago? It's a bit odd to see a new skeleton.
I acknowledge that, my lord. You haven't seen the document, so let me explain why we think it's helpful. My lords may have appreciated that our arguments in writing in respect of ground 3 are very brief, and it seemed helpful when I was preparing the case last week to set out our position in writing in a little more detail, and that's why we prepared the supplementary skeleton argument.
Well, skeleton arguments are supposed to be that, skeletons, not
Indeed.
full written arguments.
Certainly, it's a brief document, and if my lords, my lords haven't seen it.
Well, you make your submissions. I can tell you that we have read the Upper Tribunal's decision. We have read the skeleton arguments. We have read the relevant rules. We have also read AB Jamaica, Runa, and is it NA Bangladesh?
Yes. Thank you. Thank you very much, my lord. Well, I think in terms of the supplementary skeleton argument, I would formally invite the court to grant permission and to look at it in due course.
Well, I
if
think
my
until we've seen it, we're not going to grant permission. I don't like granting permission for a document I've never seen.
Of course, of course. Well, that's our position. We will provide copies of the skeleton. I think we've got hard copies here. I don't think we do. I'm very sorry.
We'll try and retrieve it from e-filing if it's been e-filed.
It would be helpful to have an explanation as to why it wasn't before us on the last occasion, which was some weeks ago, because the appeal was due to be heard then, so it's not clear why there's a need for supplementary skeleton in these circumstances.
Yes, my lord. The only explanation I can put forward is the one that I've given a moment ago. On preparing the case last week, it struck me that the court would be assisted by more detailed written argument, albeit relatively brief written argument, fleshing out, if you like, our position in respect of ground 3. That's the basis for the submission of this supplementary skeleton argument.
I'll ask the clerks to print it out and bring it up.
But my lords, the reality is I can develop the points that are set out briefly.
Well, we're going to ask for the thing to be retrieved from e-filing and brought in. So we'll go from there. Anyway, you make your submissions.
Thank you very much. I'm very grateful. And I'm not sure why the document hasn't reached you. Obviously, it's late, and that's an issue. But we'll provide copies as best we can. So, if I may, my lords, what I propose to do is to deal with ground 3 first. That's the point of construction, as my learned friend suggests, and we respectfully endorse that structure. Secondly, ground 1, and then thirdly, ground 2, because ground 2 makes a short point which is conceded, and so I don't need to spend too much time on that ground. Unless my lords would like me to proceed in a different order, that's how I propose to proceed.
That's fine.
So in terms of ground 3, our submission in respect of the point of construction raised by ground 3 is that words in paragraph 2971F mean that they apply only where the intention of the applicant for indefinite leave to enter is to join the one parent or the one relative that is mentioned by paragraph 2971F.
How does that help you on the facts? There is only one parent with settled status.
But the intention, my lord, and I can take my lords to the decision that was challenged by way of the proceedings below to support this. The finding of the decision maker was that the respondent's intention was to join both parents in the United Kingdom. And it was on that basis that paragraph 2971F was considered by the decision maker to be inapposite or inapplicable. And we uphold that approach.
Well, you'll have to take it through the application, because the application, I think, doesn't even mention the mother.
I think
that the sponsor is the father.
that's right. There's never been, I can do that, my lord. My learned friend may be able to help. There's never been any dispute that it was always the respondent's intention to come and join both parents in the United Kingdom. If that is disputed, then I acknowledge that this point of construction may not get me all the way home, but that's been the way that the case has been argued. That's the basis upon which the case was argued below. It's the basis upon which this point is relevant, we submit. And so my learned friend can clarify the position.
So what are you trying to read in to paragraph F? Because if you read in the word only, it doesn't help you on the facts. You've got to read in something more, haven't you? And it is that parent only whom the applicant wishes to join.
Yes, that's
You've got quite a lot to read into paragraph F to get it to mean what you want it to mean.
We would respectfully submit that that's not necessarily the right way to look at it, with great respect. What paragraph 2971F doesn't say, we say, is as important as what it does say. All it refers to is one parent or a relative in terms of the parent that the child is intending to join. And we submit that the absence of any mention of another parent is an indicator that the rule does not apply where the intention is to join both parents.
Are other parents or relatives allowed to be in the country?
Yes, my lord. Our submission is, in this case, the respondent's mother has been granted limited leave under Appendix FM. And I'll take my lords right away to the decision that was challenged below to contextualise my arguments. But the decision makers in this case concluded that under the scheme of the immigration rules, it was appropriate to grant limited leave to remain.
So before you go away from my question,
Yes.
so a child can have any number of relatives or indeed other parents in the country under any status of immigration. Your objection focuses on the situation where, as a matter of fact, the child would be wishing to live with both parents. Is that it?
Yeah, so the submission is that paragraph 2971F requires that the applicant is seeking to accompany or join only one parent or a relative, and that the parent or relative must be present and settled in the UK. That's our submission. The rule does not apply where the intention is to join both parents, only one of whom is present and settled in the UK. And we'll look at the rule in a moment, but and in due course I'll make this point, that the purpose of the rule is to allow a child to settle with a parent or a relative who is settled themselves. It's not to provide a shortcut to settlement where other rules are available that allow for the child to come into the UK and live with both parents.
If the parents were divorced or were in the process of divorcing, would it be all right to say, well, I'm going to live with my father?
There are other rules that apply there, my lord. Perhaps it's helpful if we turn immediately to the text of the rule. Paragraph 2971F is, if you like, an escape valve provision. But our submission is that it only applies in the way that I've indicated, where the intention is to join only one parent, and that parent or relative or a relative, and that parent or relative must be present and settled in the UK. Rule doesn't apply where the intention is to join both parents, only one of whom is settled.
And you get that from the absence of mention of the second parent.
Considered in context, the immediate and the wider context, and bearing in mind the purpose of the rule. That's our submission, my lord. So if I can take my lords to the text of the rule. So that's in the main authorities bundle, behind tab 2, on page 53, so 53 for the electronic, tab 2 at page 53 in the hard copy. And so my lords will see that there are a number of circumstances covered by the rule in the subparagraphs from A to F. The opening text of the rule refers to the applicant's intention. Requirements to be met, this is the very opening text, the requirements to be met by a person seeking indefinitely to enter the United Kingdom as the child of a parent, parents, or a relative present and settled, or being admitted for settlement in the United Kingdom. And then you get to Roman 1. Thank you very much. Then you get to Roman 1. Is seeking leave to enter or accompany or join a parent, parents, or a relative in one of the following circumstances. Now we submit that the situation where the intention is to join both parents is covered by subparagraphs A to C, because those rules clearly cover those circumstances. A and B use the expression both parents. C opens with the reference to one parent, but the remainder of the subparagraph makes it clear that it also covers the situation where the other parent is being admitted on the same occasion for settlement. And then the remaining paragraphs, D to F, we submit, deal with the situation where the intention is to join one settled parent in the United Kingdom, or in the case of F, also a relative.
Why, as a matter of logic, should a person who has one settled parent and one unsettled parent be worse off than the people in B, C and D?
The answer to that, my lord, is that the overall scheme of the immigration rules caters for the situation where both parents are settled in one way. In that situation, the applicant is given, if they meet the requirements under 297, indefinite leave to enter. But
that's A.
I'm sorry.
That's A.
It is, yes.
That's about B, C, and D. Why should a person who's got one settled and one unsettled parent be worse off than the child of parents under B, C, and D?
Yes, my lord. So I hope the pithy answer is that the scheme of the immigration rules provides that in that situation, only limited leave is granted, and for better or worse.
At the moment, I'm trying to rise above these rules.
Yes.
And ask you for a single good reason why a person with one settled and one unsettled parent living together in the UK, why that child should be worse off than a child of falling within B, C and D.
Well, I think on my feet, my lord.
Was your answer just the rules say so?
I'm afraid that's the only answer I can give immediately.
That was your answer then?
Indeed. That is the settled decision of Parliament and the Secretary of State in the immigration rules.
But actually, it's not only that there's no logical reason, it's flat unfair that a child in that situation should be worse off. No, should be worse off than those under B, C, and D, isn't it? I mean, just a matter of. So what could Parliament have possibly been seeking to achieve by discriminating against child? Because it really isn't any answer to say, well, we can go to Appendix FM or wherever the next port of call is. I'm just giving you the opportunity to say whether there is any foundation in reason for the strained interpretation that you're urging of F.
I've made the point that I've answered my lord with is the point that this is the approach that the immigration rules have taken, and that is sufficient.
Well, it is if you're right.
Indeed.
But if you're wrong, then an individual in that situation falls perfectly satisfactory so far as the justice of the situation is concerned within 297.
Yes. My lord, the traditional position has been, and this remains the position, that a grant of indefinite leave to enter or indefinite leave to remain is a privilege and not a right. So it's only in unusual circumstances that indefinite leave to enter or remain is granted. The reality in this situation is that the legislature, and the Secretary of State is sort of quasi-legislature, has a decision to make as to whether to grant leave to remain or whether to grant indefinite leave to remain in circumstances where the intention is to join both parents, only one of whom is settled and the other has limited leave. Either you grant the limited leave in line with the position of the non-settled parent, or you grant indefinite leave in line with the position of the settled parent. The position that has been taken for a considerable period, and I'll take my lords through the rules that bear this out, by the legislature and by the Secretary of State, is that the leave should be granted in line with the non-settled parent in that situation. And in my submission, that's a rational position to take.
If you look at the rules as a whole, clearly if no parent is settled, you wouldn't want to give a child more than the parents have got. But if one parent is settled, you then look to see if there are reasons why the child should be allowed to join them. One is where the other parent is dead. Another situation is where it would be contrary to compelling reasons that they should be joined.
Yes.
And those are the two things. One, they're not getting something more than a parent has got. And secondly, there are compelling circumstances. I can understand that often one parent will be in one country and one parent will be here.
Yes.
But if in fact one parent is here, so one parent is settled, and if in fact there are compelling circumstances, because you're living with an aged grandmother and you want to live with your father and your mother, it's hard to see why the rules and the purpose of the rules isn't met in those circumstances.
Well, I think I've said all I can on that. Perhaps if we were devising a new scheme, a different approach could be taken, but I would urge the court to respect the position that has been taken by essentially the legislature under the Immigration Act 1971 for a considerable period of time. And in my submission, that position, as I've outlined it, is a rational one to take. Either the immigration rules, if you like, would level up or would maintain the position of the person with limited leave in terms of the grant of leave to the child. A decision has to be taken as to which of those positions to adopt, and the immigration rules has consistently taken the position that it's limited leave and not indefinite.
You say that, but that depends on what the rules mean. If in fact we construe the rules to mean if it's one parent with settled status and the other requirements, whichever they are, whichever rule are met, then the immigration rules as made by the Secretary of State and laid before Parliament, but not actually approved by Parliament.
Indeed.
That has always been the position. What you're telling us is that some Home Office officials might have misread the rules.
No, my lord, what I've submitted is that the overall scheme of the rules, and I'll take my lords through this now actually just to make this point good. The overall scheme of the rules in a situation where the intention is to join a settled parent and a parent who has only limited leave but with a view to settlement, the scheme of the rules in that situation is to grant limited leave to the child in line with the limited leave in respect of the parent who's not settled.
Just before we leave 297, can I ask you another question?
Of course.
297, the opening rubric talks about the child of a parent, singular, parents, plural, or a relative.
Yes.
Then Roman 1A to E are all about parents.
Yes.
F now extends to a relative.
Indeed.
So if a child wishes to go and live with their uncle and aunt, does that fall within F on your only one interpretation?
I mean, I'm conscious of the word a relative. So on the face of it, the rule wouldn't apply there, but that would raise
It
different...
wouldn't apply.
The rule
So
wouldn't...
if I want to go and live with my uncle, that's all right. But if it's my uncle and aunt, that's not.
On the face of it, the reference to a relative is singular. But I would acknowledge that would be a harder case because the policy justifications in that situation would tend to support a more expanded meaning. I wouldn't, for example, be able to point to the context of the preceding subparagraphs, A to C, as covering the ground, and I wouldn't be able to point, or maybe I would actually, but it would be less easy for me to point the overall scheme of the rules as supporting my position. So that's what I can say, my lord. Can I finish looking at subparagraphs A to F before I take my lords to the rules that bear out the point that I made, that the policy and legislative choice that's been made here is to grant limited leave and not indefinite leave to a child who's seeking to join both parents, only one of whom is settled. So the submission is, just not to lose, in order not to lose sight of this, that A to C cover the ground in respect of both parents, and D to F cover the situation in respect of a applicant seeking to join a single parent who is settled, or in the case of F, a relative. And I've acknowledged that there might well be an argument that would be difficult for me to counter, that a relative should be given a broad meaning and might cover more than one relative. Subparagraph E is worth looking at. There's authority on how it works. One parent is present and settled in the United Kingdom, or being admitted on the same occasion for settlement, and has sole responsibility for the child's upbringing. Now that provision has been interpreted consistently with our submission in respect of 2971F as only applying where the intention is to join the sole parent who has sole responsibility. That was held in a case called TD, Yemen, which is at tab 3 of the hard copy of the authorities, page 57 and following. And can I ask my lords to look at paragraph 48 of that decision on page 70? And
Can we just look at the facts first? Do you mind if we see what it was about?
Of course. So the facts are set out at paragraph 1 on page 57 overleaf and overleaf. So that's the factual context against which paragraph 48 should be read. Paragraph 48 is on page 70 and 71. I invite my lords to read the whole of that passage.
Sorry, the reference again.
It's page 70, my lord, paragraph 48. Continues on the next page.
the mother living in the Yemen or in Britain? In this case, looks like she was living in the Yemen.
Yes, she was.
And they wanted to join a father who'd had no involvement with them at all.
Yes. So yes.
So it doesn't deal with the situation where both the mother and the father have differential status. Like, yeah, I'm just looking at sole responsibility. So he met the one parent, but he didn't meet the sole responsibility.
That's right. So it's dealing with 2971E, not F. But I'm just building to a point that I say is indicative of the right approach to 2971F.
And so I've not caught up with you yet about this, so
Of course.
don't move on too quickly from it. But the analogy that you seek to draw from TD to sub F is what?
At paragraph 48 that I was just inviting my lords to read, I'm not sure whether everyone has read it. It's stated in terms. So if we go to page 70,
Yes.
It's stated in terms that paragraph 2971E is concerned with settlement where one parent is in the United Kingdom and the other is abroad and will remain so. Paragraph 2971E has the potential to split up a family and separate a child from one of its parents abroad who is involved in its life, is only the requirement of sole responsibility, which acts as a control mechanism. So there was a clear decision. This is part of the ratio of TD, and it's not been doubted as far as I'm aware in commentary or any subsequent decision, that 2971E only applies where the intention is to join the parent with sole responsibility and excludes the case where the other parent is in the United Kingdom.
But it didn't, that simply weren't the facts, the ratios for the facts, and that's why I asked. The mother was in the Yemen and the father was in the United Kingdom. It simply doesn't say anything about the situation where the father is settled and the mother doesn't have settlement, and then they want to come and join the father. They wouldn't be able to get in because the father doesn't have responsibility, certainly not sole responsibility. But that's a different situation from what we're dealing with.
Of course it is, and I acknowledge.
It's not a ratio binding on this case.
Well, it wouldn't be binding in any event because it's a decision of the upper. But I take my law's point. But my submission is that the law was correctly stated at paragraph 48 as part of the reason for the decision, and it couldn't be clearer. I read the passage that I rely upon.
One of our tasks, I think, correct me if this is wrong, is to interpret legislation or quasi-legislation having regard to its purpose.
Indeed.
And the purpose, we are told, of Rule 297 is to maintain or effect family unity.
Yes.
So it would not serve that purpose, would it? If you have one parent in the UK with settled status, the other parent in the UK but without settled status, and you prevent the child from joining them.
Well, that is the overall purpose of 297, and we acknowledge that. The purpose of 2971F, we say, is slightly narrower, and I mentioned this earlier. We say that the purpose of that rule is to allow a child to settle in the United Kingdom to join a settled parent or a relative where there are serious and compelling family or other considerations which make exclusion of the child undesirable, etc. The purpose is not to allow a shortcut to settlement. And the situation where, and I will need to come to this because I'm conscious that this is a point that's looming large, the situation where a settled parent and a non-settled parent are in the UK and the child wants to join them is covered specifically by other immigration laws. And so there's no difficulty in terms of family unity insofar as other rules cover the same ground. So yes, I acknowledge that the overall purpose of 297 is as indicated in TD Yemen, but in my submission, one has to look at the specific purpose of 2971F as well. And that is as I've indicated, and it does not, in my respectful submission, tend to support the Upper Tribunal's construction. So if, before I move away from TD,
Yes, Just looking at E with your submissions in mind,
Yes.
does it follow from what you're saying that your position would be that, let's suppose you have a settled mother, for example, in the UK wanting to bring a child in,
Yes.
and there happens to be a father who is in the UK that has nothing to do with the mother,
Yes.
has had nothing to do with the child, but just happens to be on shore.
Yes.
My understanding of your submission is that E therefore doesn't apply.
Yes. That's
Right, so that the irrelevant father can sabotage route E.
well. No, because in that situation, the father wouldn't actually be irrelevant. The purpose in that situation of the applicant is to come and live with mother and, to use my lord's expression, irrelevant father. But clearly,
So it wasn't to live with. I mean,
I
I've got a father who's in Aberdeen,
I see. Yes. No.
who happens to be within the United Kingdom, has never, is estranged from the mother.
Yes.
They haven't met since the conception.
Yes.
And he's had nothing to do with the child, hasn't got parental responsibility, and clearly does not have any responsibility within the meaning of the rules
Yes.
for this child.
Well.
Your submission would devolve to saying that's just unfortunate. We can't do E because he's in the country.
No, I'm sorry, I misunderstood my lord's question.
Is that not your?
No, the submission is that because the intention of the applicant is in that situation only to live with the parent who's solely responsible, and as you say, the other parent is irrelevant. They just happen to be in the United Kingdom. Then 2971E would apply. However, I acknowledge that the text of paragraph 48, and in particular the words "and the other is abroad and will remain so," suggests otherwise. But that's not an issue for this court.
But isn't I mean, you were relying upon what the UT judge said at paragraph 48, and he appears to be saying what I was putting to you, which is that it's for parents where you've only got one in this jurisdiction.
That is what he's saying.
That's not what you're saying.
What I'm saying is that this decision informs the correct interpretation of 2971F. Our submission in respect of
You don't
297.
even agree with it in its interpretation of 2971E.
Yes. So the submission in respect of 2971E is that what TD at paragraph 48 makes clear, leaving aside the point that my lord is putting to me, is that it does not apply where the intention is to join both parents.
I don't see how you can get that from TD, because a case is only authority for what it decides on the facts before it. And on the facts before it, it was dealing with a parent abroad and a parent in the United Kingdom. You can't leap from that to say, and it also decides that had the other parent been in the United Kingdom, the child would therefore be precluded from the benefit of 2971E.
Well,
because then you would say in your next case, you were distinguishing it.
yes. With respect, Lord, I would rather not get into a discussion about the precise contours of the doctrine of precedent. Our submission is that paragraph 48 TD is part of the ratio because it sets out the tribunal's analysis of 2971E, its construction, I should say, of 2971E, which it then applied to the facts of this of that case. I acknowledge, in the light of the point that was put to me by my Lord Justice Peter Jackson, that the assertion that the other parent has to be abroad might be difficult to defend, but the core reasoning here in my submission is correct and is supportive of our arguments in respect of 2971F. And that core reasoning is that 2971E does not apply where the intention is to join a solely responsible parent and the other parent, who's not solely responsible, has no responsibility.
All right. Well, I think we've got the point. I think we've got the point that you're making.
Yes. I mean, the submission is that the rule is clearly not intended to cover the case. This is 2971E, where a child wishes to join both the parent with sole responsibility and a parent who had no responsibility for the child, but who is residing in the UK with limited leave. That's clearly not what the rule is about. And going back to the text of the rule, if I may, on page 53 going over to 54, the structure and language of Rule E is very similar to the structure and language of Rule F. In particular, there's no mention of where the other parent is. And we say that is a contextual clue and a linguistic clue that tends to support the Secretary of State's construction. So I don't need the entirety of what's said at paragraph 48 of TD to be correct.
On the contrary, you disavow it.
I don't, yes,
You say that 2971E is agnostic about where the other parent is, but the Upper Tribunal say the other parent has to be abroad. And you, in answer to my lord, you said, well, that's not right.
It's only concerned with the situation where the applicant is seeking to join.
But it's not focusing on geography, it's focusing on responsibility.
Yes, I mean, I'm to be clear, we're not looking at 2971E. TD at paragraph 48 has been treated as good law for a long time. My submission, though, is whether or not the passage in TD at paragraph 48 that indicates that the rule doesn't apply where the other parent is in the United Kingdom, that's not material to my submission by reference to paragraph 48 of TD. What paragraph 48 of TD makes quite clear, and this is what we rely upon, is that 2971E is not concerned with a situation where the applicant's intention is to live with both the solely responsible parent and the parent who has hitherto not had any responsibility. That's the submission.
Right.
That is supported by the clear purpose of E. I mean, why would Parliament say that it's appropriate to grant someone settled status to come and join both parents in the circumstances covered by E? There's just no good reason for that, we submit.
So you could say that what Parliament is concerned with is two things in both E and F. One, that a parent has settled status, so that a child is coming to a parent that has settled status, and two, that there are reasons justifying the grant of leave. If the parent is the one with sole responsibility, wherever the other parent lives, they can come. If it's coming to a parent or one parent who is settled, and there are serious and compelling circumstances to justify that, they can come. And it's not concerned with the location of the other parent at all. If the situation truly is one parent in England and one parent in the Ivory Coast, and you're taking a child from the mother that she's grown up with, you might think, hold on a moment.
Yes.
But where both of them are here and they're living with their grandmother, it's hard to see why each limb linguistically is not satisfied, and it's hard to see why the purpose is not satisfied. And to say it's a shortcut and you start with limited leave is to beg the question. That's the answer you want to arrive at. It doesn't tell you what the rules mean.
Yeah, again, we need to look at the context of the wider rules, which I'll come to right away. But before I just move away from 297 itself, can I just draw attention to sub 4 on page 54? This paragraph deals with accommodation, and you can see that it refers to the provision of accommodation by the parent, parents, or relative the child is seeking to join. So we submit that that language does tend to support our submission, that the circumstances set out under sub-Roman 1 correlate to or tally with the intention of the applicant in the way that I've indicated. Now, if I can turn to the wider context,
Yes.
because I think this is our crucial point in the light of the colloquy. Other immigration rules cover the situation where a parent, where where the intention is to join one parent who's settled and the other who has limited leave to remain with a view to settlement, either under Appendix FM or under the predecessor provision, paragraph 301. Paragraph 301 of the immigration rules is in the supplemental authorities. That's behind tab 1 of that bundle, if you have tabs, and begins on page 5. Now, this rule follows immediately from the groups of rules that deal with indefinite leave, either indefinite leave to enter, 297, or indefinite leave to remain, 298. And what it covers is the situation set out in 301. Covers the requirements to be met by a person seeking limited leave to enter or remain in the United Kingdom with a view to settlement as the child of a parent or parents given limited leave to enter or remain in the United Kingdom with a view to settlement. And you will see that the first circumstance that is covered by that rule is the situation that's broadly this case. Now, this rule, to be clear, does not apply because it's been, there are transitional provisions that say it still has, in principle, some relevance, but since Appendix FM was brought in, Appendix FM has basically replaced paragraph 301. So Appendix FM is relevant to this case, but paragraph 301 in my submission is important to bear in mind because it was part of the scheme of the rules that existed at the time that 297 was introduced.
What were the timings for Appendix FM to be in place?
So Appendix FM was inserted by Statement of Changes HC 194 from the 9th of July 2012. There are quite detailed transitional provisions which we can provide if you want to look at them, or we can provide a joint note as to the relevance of 301. But the short point is that in our case it's Appendix FM, and in most cases it's Appendix FM. So you will see that under 301(1)(a), the rule specifically cases the situation that would be in point if 301 were applicable.
But this is for a person seeking limited leave to enter.
Yes.
And this isn't such a person.
I acknowledge that, but it would be strange, this is a submission, as a matter of the overall coherence of the rules, if this rule could effectively be denuded of practical value because you could just rely on 297. So this is a contextual indicator that tends to support our construction of 2971, and in particular 2971F. And I also draw attention to sub C, which is particularly telling in my submission. That's on page 6. Now, when you get to, if you get to my supplementary skeleton argument, you will see at paragraph 8A that I've referred to 3011D. That, I'm afraid, is a slip. It should be C. There is no D. But if we look at C on page 6, the Lords will see that the wording is materially identical, with one important change to that of 2971F.
So I'm looking at page 6 of the main authorities bundle, am I?
I'm
No,
sorry,
supplemental.
supplementary.
You're in the supplemental now.
I'm so sorry, my Lord.
Sorry.
I obviously wasn't speaking loudly enough earlier. Yes, so this is supplemental bundle.
Okay, it's
tab
the end
1.
of, it's the bit that's cut out of the main one, yeah.
That's right. We omitted all of 301, so we've included it in the supplementary bundle. So it's on page 6 for sub C. Sub A is at the bottom of 5. So one parent is being or has been given limited leave to enter, etc., with a view to settlement, and there are serious and compelling family or other circumstances, etc. Now, there are two differences really with this rule, 3011C and 3011F. The first is that it covers a situation where well, the main difference, the only real difference, is that it refers to one parent being or has been given limited leave to enter or remain with a view to settlement. Instead of referring to a settled parent or a relative, so that's the other difference, doesn't refer to a relative for whatever reason. This refers to the situation where there's one parent who has limited leave with a view to settlement. Now, our submission is that this rule essentially covers the same ground as this case if the Upper Tribunal and my learned friend for the respondent are correct. It covers the same ground as covered by 2971F in this case. And we submit that is incoherent.
Can we go back a stage? How would you express the difference between indefinite leave and limited leave?
Yes. So indefinite leave is leave without any restrictions as to duration or condition.
Duration or condition?
Or condition. Limited leave is leave that has a limitation almost always as to duration, but also it can include conditions.
What sort of conditions?
So no recourse to public. Well, in this case, there probably wouldn't be, but actually there would be. So, for example, no recourse to public funds. That would be a condition.
Does that mean no health care? No free health care?
Yes. I mean,
So if you're, I mean, what's the? And I appreciate the needs of running a proper system, but
yes.
If you have a decision which is that a minor child, particularly, for example, a small child, not a child in this case, but a minor child is being reunited with however many parents on a permanent basis, as it were. That the idea is, you know, they're cutting their ties with country of origin, coming here on what's obviously intended to be a family reunification basis with however many parents. What would the thinking be for making that child the subject of restriction either of duration or of condition?
Well, it would reflect the policy choice that the leave should mirror that of the non-settled parent. Can I just be clear? I need to just double check about the no recourse to public funds condition extending to NHS treatment. I'm not sure that's right, actually.
Right.
But it would mean you wouldn't have access to benefits, for example, in the normal case.
You wouldn't have access to housing, things like that either.
Things like that.
But I think the NHS is different.
That's right.
If it's emergency treatment, you can get it.
Yes.
But if it's not emergency treatment, I think you can get it and you can be billed for it afterwards.
Grateful. And that, I mean, there is authority on this, the position that no recourse to public funds is a component of a grant of leave under Appendix FM, which I'll come to, reflects the legislature's policy choice about limiting access to benefits.
So when we're looking at this through the lens of limited leave, let's suppose you have a parent who is settled.
Yes.
And one parent who is here unlawfully.
Yes.
Where do you fall within 301?
In that situation, you wouldn't be covered.
You don't.
No. That's the. I mean, on the logic of our construction of 2971F, that would carry over.
So in that situation, even if you were looking at the much more limited rights that accrue under limited leave to enter or remain,
yes,
you can have on your construction the, as it were, sabotaging second parent.
Well,
under this rule,
the
parent who's either together or not together,
yes,
who does not have limited leave themselves, it wouldn't fall within this.
that's right. That's not though we submit a lacuna or a difficulty, because there's always the possibility of a grant of leave outside the rules for Article 8 or other reasons.
Yes, but
And
that's
the
not
rules have to draw
guaranteed.
limits somewhere. I'm
Yeah.
so sorry, my lord.
But that's not guaranteed. So if you're looking at the rules,
Yes.
the obvious place to go, and indeed under Article 8, you'd still look at the rules first. And if they couldn't qualify here, they could under 297. And the implication underlying my Lord's question is, why on earth would you be better off if one parent was here unlawfully, as compared with both parents here lawfully, one settled, one limited leave?
Yes, I acknowledge that that's an oddity of the scheme. I imagine it just wasn't thought about at the time. Perhaps because it was assumed that it wouldn't be appropriate for a child to seek to join both parents, only one of whom had any lawful status. It was just assumed that people wouldn't be in the UK lawfully and be able to effectively and to rely on that situation as a basis for a grant of leave under the rules. I think that's what I can say about that. But the submission I'm making by reference to 301(1)(c), and I'll come momentarily to Appendix FM, is that on my learned friends construction, 2971F, and the logic of that construction, 301(1)(c) would cover this case, assuming 301 applies. But no one in their right mind, no rational person, would rely on 301(1)(c). So that indicates an anomaly we submit that doesn't arise on the Secretary of State's construction.
And you can also see it's not 301(1)(c), I think, that is the problem for you. There are all sorts of other things. I mean, it may be your mother has got limited leave, and you hate your father and he's had no contact with you, and it's your mother going to live with. She's the one that's got to be able to accommodate you and so on. And that's why it's one parent is being or has been given limited leave to enter. There's no question of a connection with the settled parent.
Yes.
The real problem, I think, for your argument or for your opponent's argument is 301(1), because there you do get limited leave in situations where one parent is present with settlement and the other is present with limited leave. It's 301(a) that you say is the problem, I think, surely.
Yeah, I agree with that, my lord, that A clearly supports the point I made about context and how the immigration rules deal with this situation. But it may be that it may be that it's not my strongest point, but we say it is at least an oddity and indicates incoherence in the scheme overall. But at least when you look at the facts of this case, C would apply just as much. 301(1)(c) would apply just as much as 301(1)(f), but no one rational would use C in that situation. That indicates an oddity we submit. Can I deal with Appendix FM, which is the current framework? That is behind tab 1 of the authorities bundle. And we see a similar problem arising in respect to the respondent's construction under Appendix FM. So the rules that deal with leave to remain for a child begin on page 32 behind tab 1 under the heading Family Life as a Child of a Person with Limited Leave as a Partner or Parent. The relationship...
31?
32, page 32.
Oh, 32, so the main.
This is the main authorities bundle again. Thank you. The relationship requirements are on page 33. And in particular, EECC 1.6 covers this case. And the arguments I've been making in respect to 3011C, about it covering the same territory in this case as 2971F, also apply my submission to sub C. There are serious and compelling family or other considerations, etc. And if we move down this section of the rules and look at page 35, there's a specific rule that tells decision makers what to do if the requirements in Appendix FM are met. It's DECC 1.1. It was applied in this case.
It's my fault, but I just want to keep track with you. You say that 1.6 applies to this case. on page
Yes.
3.
Yes,
That's your starting off point for this
that covers this,
submission.
that covers.
So you're saying, right, so but why aren't you saying this doesn't apply because both of the parents are here?
Oh no, this applies where there are both parents. One of so.
Yes, no, no, I'm just for a moment pausing on why that gives you no difficulty when it says one of the parents must be in the UK. I thought the logic of your argument was, oh well, that shows that only one of the parents
Yes,
must be in the UK. I mean, isn't that the same
yeah.
trope?
So what the difference there is that if you look at the context, it's quite clear that the parent with limited leave may be a parent, may be the partner of a settled person. So if you look at
I understand how you might get that, but it seems odd that one should be thinking of applying under 1.6 by virtue of one's connection with a person with limited leave, one of your parents, when you've actually got a parent who's settled in the same family home.
Yes.
So why does this help you? Because firstly, it seems to be, to use your, you'd have to be mad to apply under this provision, linking yourself to your unsettled parent rather than to your settled parent. And secondly, why do your canons of construction not include the word only under 1.6?
Well, it's the context of ECC 1.6 that deals with that latter point. And I mean,
We say context, but that's another word for saying it's what I wanted to mean. There's nothing there that you can point to in the rules. It's because you can't point to anything in the rules, you say, oh, well, it's the context.
well, if you look at A, my lords can look at A on this point, the applicant's parent's partner under Appendix FM is also a parent of the applicant.
Yes.
Now, to be sponsored as a partner under Appendix FM, you need to be settled. So it's clear looking at the overall context of this rule, the immediate context of A, and the wider context of the provisions in Appendix FM, that it clearly covers the case where the intention is to join both parents, one of whom is settled and the other of whom has limited leave under Appendix FM. It wouldn't work otherwise in my submission. So that's the point with respect. And at sub C, just again not to lose sight of this point, we say that that provision would cover the same ground as 2971F.
Sorry, I'm lost. Which sub C are you looking at?
On page 33, my lord.
ECC 1.6C.
Yes, thank you. So this uses the same expression, serious and compelling family or other considerations which make exclusion of the child undesirable, etc.
So the argument takes as its starting point, if I've understood, that the sponsor must be settled. Is that right? Is that what you just said?
So in terms of an, if the sponsor for the purposes of a partnership application, so an application made by a partner for leave to remain in order to stay with their partner, the partner would need to be settled. So the way this effectively works is that you get limited leave to remain as the spouse or partner of a settled person, indefinite leave to remain or a British citizen who's present in the United Kingdom. And then your child is eligible for limited leave in line with the limited leave granted to the parent who is not settled, pursuant to Appendix FM. That's how this scheme operates.
Well, we don't know anything about that. We know that the partner, who may not be married, has to be the parent, the biological parent of the applicant. It doesn't say anything about whether that parent has settled status or non-settled status, or whether they left the United Kingdom now. All that's saying is if somebody wants limited leave and they're relying on a relationship with, I assume it's the mother, because it often is the mother, and the mother has got limited leave through the partnership route, then the person that she's got the partnership thing from must also be the parent of the child.
Well,
A says,
yeah. Well, so
looking at it,
A assumes that A covers the case where there's a partner under Appendix FM, who is also the parent. Now, the partner under Appendix FM would be settled. That's the point. So if we look at what the rules tell decision makers to do, if you qualify under this scheme, and this applicant does, this respondent does, DECC 1.1 covers that situation. It's on page 35. And it couldn't be clearer. I'd invite my lords just to look at the text.
But the problem that you've got is that
Sorry, just wait. Which paragraph are you looking at with this now?
D-ECC 1.1 on page towards the bottom of 35.
So they
Should be
get
line
limited. They get limited entry clearance.
In line with the non-settled parent. Yeah. And we say that that's been the scheme of the rules right from the outset, from the time that 297 was introduced. I've taken you to 301 that bears that out, we submit. Now, if the Upper Tribunal's construction of 2971F is right, this provision is effectively overridden. And we submit that would be incoherent. The Upper Tribunal tried to deal with this point by reference to a transitional provision in Part 8, which is the subject of Ground 2. And I'll come on to that separately towards the end of my submissions. But it's been conceded, that's all I'll say at this stage, it's been conceded that that transitional provision doesn't apply. So it must be right that on the respondents and the Upper Tribunal's construction of 2971F, there is an incoherence in the rules because there's an entitlement on that construction of 2971F to indefinite leave to enter. But DECC 1.1 tells decision makers in mandatory terms will be granted to grant only limited leave. That incoherence does not arise on the
choice.
Secretary of State's construction.
The choice is between levelling the child up and levelling the child down.
For some reason, I was avoiding putting it like that, but that's right, my lord. That's what I was trying to say.
I think it has been used within the papers, but your submission is that the rules intend that the child shall get the weakest protection, even on an application for indefinite leave to remain.
Yes, I think I would put it this way, using my lord's expression. It's level down, but in circumstances where that's sufficient to meet the requirements of Article 8 and the interests of the child. That's what Appendix FM is seeking to do. And indeed, that would maintain family unity. You're still with your parents in the UK. It's just you're subject to the requirement to make another application going forward. And you don't have the other advantages of indefinite leave.
the problem that I've got with your Appendix FM isn't 277B, it's 277. That says Part 8 continues to apply, and it applies, say, for one immaterial exception to applications for indefinite leave to remain. And therefore, that's what you apply. So it's hard to say you must qualify what 277 says by reference to something that hasn't been included. So I really think it's 301 or bust.
Well, that's what, I don't accept that, and I'll explain why. But I certainly, forgive me, my lord, but maybe I've misunderstood my lord's question. But I certainly acknowledge that 301 is informative, and that's why I've taken my lord to 301 at first before Appendix FM.
If 297 was there, and if it continues to apply, not FM, to applications for indefinite leave to enter, then that's what you look at. And what happened in Appendix FM doesn't help us. So I really do think you've got to look at the rule that was in place at the time to see if that throws light on the preserved 297.
I think that the one, if I follow my lord's question, the one difficulty with that analysis is that the transitional provisions that continue to apply 301 do not apply.
No, that's why you've got to look at 301 as showing light at the time that the rules were enacted. Because although 301 has gone, it shows light as to what the rules meant at the time, and you would say the repeal of 301 wasn't intended to change the scope of 297,
Indeed.
but it's 297 viewed through the lens of 301 as it was at the time when the rules were first made.
Yes.
With both those provisions in that applies. So I don't know that Appendix FM and whatever conglomeration of letters really helps you.
Sure. I think that, so I certainly, so just to be clear, 301 is not repealed strictly, but it's of limited application.
Yeah.
I certainly accept my Lord's point that it's an important contextual indicator as to what 297 means, and I've tried to develop that point. I think my Lord's point depends on the transitional provisions and how they operate. And this is, I obviously dealt with this too quickly. This is the significance of ground 2, and perhaps I'll just deal with that now. So if we go to the relevant transitional provision that the Upper Tribunal thought applied, it's paragraph A277B on page 51. Now, the Upper Tribunal thought that this rule told decision makers to apply Part 8 in priority to Appendix FM.
It's wrong.
We make 2 points about that. The first is conceded, and so I don't think we need the second point, but in any event. The first point is that A277B, what the rule we're looking at the bottom of 51, does not apply to indefinite leave to enter.
No, you say it applies to leave to remain.
Exactly.
Not to leave to enter.
And there's no provision that deals with leave to enter, definite leave to enter, in the transitional provisions. So what that means is that Appendix FM is relevant in the way that I've indicated in my respectful submission.
But A277 says from the 9th of July 2012, Appendix FM will apply to all applications to which Part 8 of these rules applies, except where the provisions are preserved. And if you go through the provisions of preserved, 297, subject to one exception, is preserved. So that's saying FM doesn't apply. It's the old rule that applies subject to the one exception that is in the FM. That's why I think it's 277 might be more relevant. You tell me that's wrong.
Well, the Upper Tribunal did not rely on A277. I don't understand the learned friend to rely on it either.
No,
So
but if
I
it's
may
the
need to
law-
think about it. But my immediate response to my Lord's, if I may respectfully say so, helpful reference to that provision is that it doesn't deal with questions of priority in a way that A277B seems to. Another way of
I
making
agree with that,
point.
but what I'm saying is you're saying that it's got to be read with Appendix FM, and all I'm saying is that it says it's not FM, it's Part 8, subject to one exception that's in Rule A280, which isn't material to this case. So 297 applies, not FM. So one isn't concerned about a coherence or a priority between 297 and FM. 297 applies.
But I think my point is this, my Lord. So does Appendix FM. A277 does not say Appendix FM does not apply in this case. Because
All applications except
297 applies to applications for indefinite leave to enter.
Yeah.
And Appendix FM deals with entitlements to limited leave as a partner of a settled person, as a child of a partner of a settled person. There's nothing in these transitional provisions that disapplies Appendix FM. And the point I've made by
What
reference...
about the words except where the provisions of Part 8 are preserved and continue to apply?
Well, because the provisions of Part 8 that cover the ground of Appendix FM have not been preserved or do not apply, because that would be 301, and 301
But 297
pursuant to the transitional provisions.
save to one additional importation. I don't think it matters, but I just don't see how the words accept mean anything other than accept. I mean, you don't apply FM to something that's been preserved, and 297, with one exception, has been preserved, and it's Article 280 or Rule 280, which you haven't got in the bundle, but I haven't a feeling interested.
Yes, well, as I say, it may be that I need to think about this. On my feet, the response is that A277 does not entail that Appendix FM is not applicable in this case. Appendix FM is applicable in respect of an entitlement to limited leave.
No, I accept that. That's something different.
Yes.
If you want limited leave, you can apply for it, and then that's governed by FM. But if you want something different and you're making an application for indefinite leave to enter,
Yes.
that is preserved by Article 2, Rule 280, A280, with one bit voted on from FM, and then it says that applies, not FM. So the application for indefinite leave to enter is not subject to FM, say in the one limited transitional respect.
I'm grateful. I see the point. In my respectful submission, there is still that incoherence because of what DECC 1.1 says. What that provision provides is that if you're entitled to limited leave under the appendix, under Appendix FM, as a child, that's what you get. And the decision makers in this place,
application to which FM applies.
yes, I acknowledge that. Well, you have my submission, whether it's accepted or not. This is an incoherence, we say, and I'll come to the textbook which actually supports this submission we submit very shortly. Just to draw this together before I go to the textbook, looking just at the text of 297, the fact that it doesn't explicitly refer to the position of the other parent, my submission doesn't entail that the rule is indifferent as to the intention of the applicant to join both parents. You have my submission as to how the rule works. The purpose supports that construction. The immediate context of 2971 supports that construction, and the wider context of the scheme of the immigration rules overall supports that construction. I haven't, my lords, taken you through the relevant authorities in respect of interpretation. Can I just give you the references? The leading case remains, or a useful port of call at least, remains Mahad and the ECO.
Yeah.
Paragraph 10 of that decision, supplementary bundle, page 17. That approach was applied and clarified in the more recent decision of Wang, at paragraphs 29 to 31, at pages 294 to 295. So the position is, looking at Mahad at 10 and Wang at 29 to 31, you interpret the rules in context, but looking at the language used and having regard to purpose, and you do so sensibly. What the Wang case makes clear, if clarity was required, is that that exercise of interpretation is not conceptually different from the ordinary approach to interpretation of legislation. And so general principles in respect of the interpretation of legislation are also applicable. And on those general principles, I would respectfully refer, my lords, to a case called PACCAR at paragraphs 40 to 42, authorities page 226 to 7, paragraphs 40 to 42. Those passages emphasize the importance of context and, in particular, the importance of the scheme overall of legislation. I hope the relevance of that principle is obvious in the light of the submissions I've been making. I'd also draw attention to the case of O and another, paragraph 28 of that decision, another decision of the Supreme Court. Sorry, paragraph 29, of that decision, another decision of the Supreme Court on page 198 of the main authorities. That passage sets out the ordinary approach to interpretation and emphasizes the importance of context when interpreting the language in an enactment.
Yes.
Thank you very much, my lords. Before I move away from ground 3, can I just draw attention to the way that the leading textbook has dealt with some of the points that I've made. So we've included excerpts from McDonald's Immigration Law and Practice in the supplementary bundle of authority at tab 4, beginning on page 443 and following. 43 and following, Lord. And I'll just give you the references. We've line marked the relevant passages. So it's paragraphs 11.92, 11.92, 11.94, 11.101 and 11.111 of the 10th edition. And what those passages show in my submission is that it's been the understanding of the authors of this leading immigration law practitioner's text that Appendix FM provisions apply in the circumstances of this case rather than 2971F. We've included the latest edition, the 11th edition, and I refer you to paragraphs 11.93. These begin on page 50, 11.93, 11.100, and 11.110. Those paragraphs are materially identical to the passages in the 10th edition, save that they refer to the decision of the Upper Tribunal in this court. The decision of the Upper Tribunal appealed to this court as indicating a slightly different approach. My submission.
Where's the reference?
In the 11th edition, it's in particular paragraph 11.100. It's on 53.
Yeah.
So you'll see there's a footnote, footnote 2. The footnote's on the next page. So in the middle of the text, 6 lines down, I think. And
okay, yes, I see. Yeah.
I'm grateful. Similarly, on paragraph 110, 11.110 on page 55. And again, there's just a footnote there, not a statement of the name of the case. It's right at the end of the last sentence on the bottom of page 55 before the footnotes.
Very sorry. What page am I looking to find the footnote 2?
So I've referred you to 11.110, 110 on page 55. 50, I'm sorry. So the first passage where Kone is referred to is on 53, 11.100. And again, that's footnote 2, but it's footnote 2, and you'll find that
It's on the next page,
it's on
56.
I'm very grateful. Yes, it's on the next page. It is the long footnote.
I'm sorry, I think I'm looking at the same place, but I'm just at the moment not seeing reference to the present case.
Yes.
56, top line, isn't it, Mr. Boots?
There isn't, isn't there?
Perhaps the footnote's been omitted.
No, it's in mine. It's
Oh, is it?
the quick king on the application of Lewison, Kone, but
Right,
it's
so
on the
that's
next
top of
page,
page
56.
Thank you so much.
Right, I'm just looking back to. So there's a reference at 11.110,
Yes.
and the other reference was.
Yes, so there the footnote does appear, as my notes indicate.
And where does it appear in the earlier place?
I think that's where it's omitted. That's what I was.
I thought you said a moment ago that there was a comment on this and as showing that a different line had been taken. Is that what I'm looking
Yeah.
at?
So exactly. So the two passages that are slightly different from the 10th edition in the 11th edition are 11.100 on page 53 and 11.110. on 55 going over. The footnote to 11100, I think we've omitted, I'm afraid. We'll provide it, but from memory, I think it's just the citation of Kone. There's no commentary, just the citation.
So where is the commentary on this case in this text?
So it's in the text in brackets where the word Kone or Kone appears.
At what page?
Page 53, paragraph 11,100.
And also 11.1.1.10, last sentence. And in both cases, it recites the decision of Kone. It doesn't suggest it's wrong or in any way inconsistent. And one interpretation, authors can't think of everything. A natural situation might be one parent in the UK, one parent abroad. And that's why you need serious and compelling circumstances. But there may be cases where both parents are here and culturally it's not unusual for the child to be with a grandparent or some other relative.
Yes, paragraph, the text in the 10th edition, and indeed the text at paragraph 1193 of the 11th edition, we say strongly indicates that the Secretary of State's construction is correct. And the reference to Kone in the subsequent edition is indicative of that, we submit, because it's being referred to for a reason. Effectively, the suggestion is that something has changed. Can I refer, my lords, to on this page 52, where you'll see the line mark and the line mark text on the right-hand side. This is in the 11th edition. It's section 11, paragraph 1193, which is in exactly the same terms as paragraph 1194 in the 10th edition. And I'd invite you, my lords, just to read the line mark text, beginning under the Part 8 rules.
I don't at the moment see how that advances the case.
Well, it's at least consistent with the Secretary of State's construction, we submit.
But we're dealing with a hybrid case, where one parent is settled and the other is not. And that's not the division that these editors are talking about.
It's the words "and those children who seek entry to stay or accompany or join only one of their parents, or are seeking to join a relative other than a parent" that I would emphasise. So
this lady is not seeking to join only one parent, she's seeking to join two. That was your whole point.
Yes, so but the distinction that the authors are referring to is between that situation only, where the intention is to join only one parent, where 2971F applies, and the situation where the intention is to join both, where it wouldn't apply and you'd look at Appendix FM. Now, I appreciate that this point isn't explored in terms. I can only make so much out of it.
Yeah.
But we do suggest
So
that
children who are seeking to accompany one parent fall within A, B, C, D, or whatever the case may be. They're falling within E and F.
So it brings me back to the point that I was trying to make by reference to 3011A and then Appendix FM.
Yeah.
I've got that side.
I'm grateful. Thank you, Lords. That's what I wanted to say about ground 3, and I can be a lot
Leaves ground
more
2,
precise
yeah?
on the remaining grounds, unless you have any questions on ground
Nope.
3. Thank you. So I'll deal, I think, with ground 2 because I can deal now because I can deal with it quite briefly. As I say, it's been conceded.
I thought you dealt with it.
I think I have, but let me just make sure that I've covered what I want to cover.
I mean, the case that's put against you is even if there was a mistake, it's immaterial. It was one of a number of reasons that the Upper Tribunal judge gave for her decision.
Yeah.
So even if you're right and they're bound to rights on it, so what? Yeah.
Very well. The answer to that point is that if we look at the decision in this case, going back to the core bundle, penultimate document, page 241, beginning on page, it's 241 of the PDF, page 238 of the hard copy. This is the 30th of June 23 decision that is the subject of the proceedings for judicial.
Sorry, I'm lost. You said page 241, but that's the biographic details and travel dates.
I'm so sorry, my lord. I misspoke. I gave you the PDF number. It's 238.
238.
In which bundle?
In the core, my lord. PDF 241.
So that's the decision under challenge.
That's right. And what the decision under challenge did was to apply paragraph DECC 1.1. See the text towards the bottom of page 239 of the pagination. And my submission is it was open to the decision maker to do that in the absence of transitional provisions that required something else to be done.
But the problem is, as I said, the application that was made, and indeed it was that application that you were looking at again on consideration, is quite clearly to join the father. So it's on the grounds of 297. So when it says at the top, you apply to join both your parents in the United Kingdom, thus you do not meet requirements for 297D, as you do not have a parent who is deceased. Well, she knew her parents weren't dead. That's why she was coming here. And this wasn't an application to join both parents. If you go through the application carefully, which starts at page 244, it makes it quite clear that she wants settlement, which is indefinite leave to remain, and she's coming to join her father, who's a British citizen, and she's going to live at her father's address.
Yes,
That's what the application says.
well, we can see if there's some further documentation that sheds light on this, but as I said towards the beginning of my submissions, it's always been understood that the applicant was intending to join both parents and that was the purpose of the application, and that was a basis on which the arguments proceeded below in the Upper Tribunal decided the case. So I appreciate
I understand that. I understand that the ultimate aim was to live with both her
Yes.
parents, because both her parents were married to each other and they were her mother and father. But the application
Yes,
is actually an application under 297 for settlement with her father, isn't it?
that's right. But my submission, and that's right. The submission is, though, I mean, obviously ground 3 says that it wasn't open to the applicant to rely on 2971F because it doesn't apply where the intention is in fact to join both parents, and that's what the decision maker says in this document. And obviously you'll either accept or reject those arguments that I've made. But in respect of this this point ground 2, and the relevance of the concession that the judge was wrong in respect to the transitional provisions that are dealt with by ground 2, my submission is that in the absence of transitional provisions that said that the decision maker had to grant indefinite leave to remain under Appendix FM, under Part 8, rather than do what is stated has to be done under Appendix FM pursuant to DECC Rule 1.1, it was open to the decision maker to apply DECC 1.1. Indeed, they are obliged to do that because the rule told them that if someone's eligible for limited leave under Appendix FM, they should only be granted limited leave in line with the position of the non-settled parent. That's the submission. That's why this error was material. If this point about the transitional provisions was immaterial, it's surprising, we submit, that the judge took the time to consider it and make the decision that she made.
But assuming you leave it out of account and you're down to we accept or reject your arguments about 297 and I think 301 as originally.
Yes.
Doesn't make a blind bit of difference, does it?
Well, in that situation, you would then have, if you like, the incoherence in the immigration rules that I sought to rely upon in respect of our arguments of interpretation under ground 3. The rules are pointing in different directions. On the one hand, on this hypothesis, there's an entitlement to indefinite leave to enter. But on the other hand, there's an entitlement to limited leave to enter, and there's a specific rule telling decision makers to grant only limited leave. And the submission is that in that situation, it was open to the decision maker to follow the specific rule that required a grant of limited leave, in the absence of transitional provisions that entailed otherwise. And there were no such provisions. We also say, although we don't need this argument, that actually paragraph A277B doesn't require paragraph Part 8 to be applied in priority to Appendix FM. It's simply pointing to decision makers to the need to consider Part 8 and then to go on to consider Appendix FM. It doesn't say which provisions take priority.
Don't you naturally look at what the person is asking for when you're deciding an application?
Yes, you would naturally do that, my lord. But my submission in this case is it was open to the decision maker to apply the rule that said
What in this case would give rise to the decision maker not dealing with them in order of what you were asked to deal with?
Well, in fairness to the decision maker, they did look at 2971F. They formed a view about that, which I've sought to defend by reference to our arguments under Round 3. But they also said, well, under Appendix FM, you're entitled to limited leave, and we're required to only grant you limited leave, and we're going to grant you limited leave. So my submission is that it was open to the decision maker to apply that rule.
Having rejected the case under Rule 297.
That's how it worked. That's
Yes.
right.
But I think my Lord's point is that you consider what the applicant was asking for.
Yes.
You decide whether or not she's entitled to it.
Yes.
If she is, then you stop there. If she's not, then you go on to consider whether there's some lesser entitlement or lesser privilege to which she is entitled.
The difficulty with that approach is that the rule specifically says that the applicant should be given only limited leave.
Just remind me, I don't remember it being in quite those terms. And is this back to FM doesn't apply to an application for indefinite leave to enter?
Yeah, I mean, if there were transitional provisions that meant that you only look at Part 8, you don't go on to look at Appendix FM, then this argument would fall away.
So it does turn on 277 and A277.
Yes, as I say, that's not something that's been relied upon.
Well, quite a lot of what you said this morning hasn't been raised until now, so I don't think we'll punish them for that, will we?
Just answer this very neutral question, which is there any significance between the difference in leave to enter and leave to remain, or is it for a person who's coming from abroad the same difference?
So yes, functionally they're equivalent. They apply, as my lord indicates, on the one hand to someone who's trying to come into the United Kingdom, and on the other to someone who's already inside the United Kingdom. The way it works strictly is that if you apply outside of the United Kingdom for immigration status that allows you to come to the UK, you apply for entry clearance. And under subordinate legislation, when you enter the UK pursuant to that entry clearance, the entry clearance normally takes effect as leave to enter. But in functional terms, what matters is you have the entitlement to be in the United Kingdom.
So what we're concerned with is the length and the conditions,
Yes.
not really with enter or remain.
That's right, my lord. That's right. So those are our submissions in respect of ground 2. Ground 1. Now, if we're right about ground 1, I can be wrong on everything else and still win. There are 2 short points in respect of ground 1. The first is, so just to orient ourselves to where we are in respect of ground 1. Ground 1 deals with the correct approach to the words serious and compelling family or other considerations which make exclusion of the child undesirable in paragraph 2971. We deal with ground 1 at paragraphs 35 to 42 of the skeleton argument, the appeal skeleton argument, where we set out the 2 points that I'm about to make. So the first of those 2 points is this. Even if the Upper Tribunal is right, that the test in paragraph 2971F requiring there to be serious and compelling family and other considerations, etc., is a normative rather than a factual assessment, the Upper Tribunal was wrong to conclude that the fact that the respondent had been granted limited leave to enter was immaterial to the normative assessment.
Yes, I'm not sure that I quite understand what the Upper Tribunal meant by normative. It's really a question. The question is, what is the question
Indeed.
that you have to answer?
Indeed. So there were two.
And the way that the respondent argues it, and seems to be borne out by some of the cases to which we've been referred, is that you postulate the hypothesis that the child will be refused entry or in other circumstances will be required to leave the United Kingdom, even if that's not the fact. And you answer the question on that hypothesis.
Yes, we will look at AB. The idea of applying a hypothetical test in AB was explicitly rejected, but I think I would accept my Lord's, the substance of my Lord's analysis. Essentially, you look at what the test requires. Inevitably, it's a normative test because we're dealing with a legal requirement.
Yeah.
And what was clarified in AB is that the relevant test in that case, which was under section 117B6, applied and had to be considered, even if on the facts of a given case, there was no prospect of removal of the child.
Yeah, so you postulate the counterfactual.
Yes, you apply the normative test on the invariable hypothesis that removal would happen if, on the invariable hypothesis of proposed removal. Yeah.
But that's not quite what happened here. The rule itself is talking about leave to enter. And it's presupposing that the child is outside the United Kingdom and is coming to the United Kingdom.
Indeed.
That's precisely why you ask whether there are serious and compelling reasons for the child to be here rather than in whichever country she's coming from. That's the first point. And the second point, if you're wrong on ground 3, that's what you should have asked. And you should have granted her indefinite leave if the answer was yes, there are serious and compelling circumstances, not limited leave. And by granting her limited leave on this hypothesis, you were wrong because you shouldn't have dealt with it that way around. You should have done indefinite leave to remain first.
Yes.
And when you agree to reconsider the application, what you were really saying, even if in other cases you look at facts as they've turned out, you look at the application and say, this is a woman, a child from outside the United Kingdom who wanted to come to the United Kingdom. Are there serious and compelling reasons which make it desirable for her to come to the United Kingdom? And you can't change the equation by your unlawful failure to do what you should have done in the first case, which is to look at your application.
Well, because the Secretary of State was undertaking a review, the submission is that it was open to the decision maker undertaking the review to take into account the fact that a decision had been made to grant the respondent limited leave. And
yes,
so,
I understand that, but it could have been quashed and it was the wrong way round. So on this analysis, I understand that, but what you undertook to do was not reconsider the decision. That may have been the way you expressed it, but what you were accepting was that, and I haven't seen the consent, it was probably in the bundle, that decision would be withdrawn or would be reconsidered. And that means you've got to look at the application, and the application was made by somebody who was in the Ivory Coast who wanted to come to the United Kingdom. The question is, does she meet the father requirement? Does she meet the compelling circumstances requirement on the basis that she's outside trying to get in, not on the basis that you're reconsidering on the grounds that you can take the benefit of any errors that you've made along the way?
yes. Well, the concept of a reconsideration was explored in the decision of this court in a case called Akinola. I'll just give you the reference.
Yes.
You're probably very familiar with it. It's paragraph 69 on page 175 behind tab 8, for those with hard copies. So page 175, paragraph 69. And the point that's made there by the court is that the concept of reconsideration is a wide concept, and it can take into account after the event developments. And in my submission, what happened in this case was that the 2019 decision was looked at again on a reconsideration, but in the light of the fact that a decision had been taken that established that the applicant was entitled to limited leave to enter, and indeed had been granted limited leave to enter. And my submission in respect of ground 1, the first submission in respect of ground 1, is that that fact was a material consideration on any view of how the test in paragraph 2971F in respect of serious and compelling family and other considerations which make the exclusion of the child undesirable operates. My learned friend relies on a line of cases that deals with the approach to section 117B6. I've referred to AB, and I'll come back to that in respect to my second submission shortly. But the case law that deals with the application of 117B6, in my submission, makes it quite clear that what's necessary is a fact-finding assessment that has regard to all material considerations, which can include immigration status. And one would expect that, because just as a matter of common sense, the fact that a person is entitled to stay in the United Kingdom and so will be able to stay with both parents must be relevant as to whether there are serious and compelling family or other considerations which makes their exclusion.
So I'm simply not understanding this. Your argument is a second reason why sub F doesn't avail the applicant. Is that right?
Yes. So assuming that
we will get past the main argument, ground 3. You say it would nevertheless fall at ground 1, which you're now arguing.
Yes.
So you're saying that because we've granted her limited leave, the additional requirement in F cannot be satisfied. The additional requirement being the serious and compelling reasons.
Not on the facts of this case. I mean, this argument is that it is a material consideration that the person relying on 2971F has been granted limited.
Yes, I understand, but I mean, from where I'm sitting, the fact that you had granted her limited leave would appear to be a solid reason for supposing that F was satisfied. I mean, the reason you granted her limited leave was because of her predicament in the home country and the family reunification. So why should her situation be? Why should you be able to cut off her application at the knees simply by having granted her something less, which is designed to prevent what is provided for in F? I don't understand it at all.
Well, the respondent was granted limited leave under the Appendix F provisions that we've looked at.
Yes, because of the undesirability in private and family life terms of separation and exclusion from this country. And I can't think of a better way, given your limited reading of the rules, which I'm not expressing a view on at this point, but I can't think of a better way of the Secretary of State endorsing the requirement, second requirement in F, than by granting limited leave. It seems to point directly against the argument that you're going to ground by. I'm only raising this with you because I fear I may have missed the point. If that's where it all comes to.
Well, no, I'm very grateful, my lord. I mean, the short submission is that the immigration status of the applicant is a material consideration. So if the applicant has an entitlement to be in the United Kingdom, that falls to be taken into account when applying the test in 2971. And our submission is that approach is consistent with the approach to 117B6. It's also broadly consistent with a purposive and common sense approach to 2971F, because one would think that the fact that you're entitled to be in the UK means it is naturally going to be relevant to the application of the test in that provision. Can I just briefly give my lord?
Oscar, I've looked up, I had read it because I've marked it, page 20 of the supplementary bundle, and what you actually said to do, because if what you're saying now is correct, then you needn't have bothered the consent order, because the consent order at 20 says upon the issue in this application being the decision to grant the applicant limited instead of indefinite leave, and upon the respondent agreeing to reconsider the applicant's application for settlement,
yes,
and to issue a new decision within 3 months, then the JR is withdrawn, and that's it. But if you're right, this was pointless, because you were never going to reconsider the application in the sense of forget she's got limited leave. you're not focusing on the application, you're focusing on the very thing that you're supposed to be not considering, if you like. You're focused on the fact he's already got leave. So why was the consent order? What did the consent order achieve? What would a person expect you to be doing after that consent order?
If my Lord's interpretation of this consent order is that the Secretary of State was obliged to disregard, on the facts of this case, the grant of leave to remain that was made in 2019. So irrespective of my arguments about how to approach, in principle, 117B6,
Yeah.
I accept that would be fatal for us.
You accept that?
I mean, it's not an argument that's been run, but I accept that would be the implication. But the point I'm dealing with here is a point of principle as to the correct approach to the test in 2971F. And I pointed out that the concept of reconsiderations is a broad one and can involve looking at post-decision to be reviewed or potentially application to be reviewed development.
I mean, that's general public law. The reason why it's different here is because you've agreed to do something on a specific basis. You must have been considering indefinite leave because that's what you said you were doing, because that was the application and that was the issue. So it's hard to see how the answer must be, well, you already knew. We granted you limited leave.
Well, I hope I've made my...
Yeah, so
I
you
mean,
accept that.
because we would be bound by what on the court's interpretation of this consent order was in fact
But
agreed.
in your interpretation of it, this reconsideration was doomed. There wasn't any point in it, because you had at least two in-principle reasons which didn't relate at all to the later circumstances of the applicant, and why she was never going to get settlement.
That is the logic of our position, that when the application came to be reconsidered, in the light of the grant of leave, assuming that we're right that the grant of leave was a material consideration when applying 117B, when applying 2971F, then we do submit that in the circumstances of this case, that undermined the
I wasn't
claimed
talking about the
entitlement
logic.
to
We agree it's the logic of your position. I perfectly understand that and may be right. But what the point, my lord, is, as I understand it, drawing attention to, is the reality of the situation, which is that this was not really a reconsideration that was ever going to lead to a different result. It was predetermined by the position that the Secretary of State was taking.
The reconsideration was a good faith look again at whether it was appropriate to grant indefinite leave to enter under 2971F.
And the answer is no, because she doesn't need it, because she's got limited leave, and she had that when you agreed to the consent order. And it was never a reason for refusing her.
Yeah.
And there was the first tier tribunal decision saying, yes, of course she should be with her parents, but she hasn't got the TB certificate. But you still say, having led the court to that conclusion, it's open to say, well, we've got other reasons now.
Yes, I mean, on the point about the first tier tribunal's decision, we say that the fact that the applicant was granted leave is a change of circumstances that could properly be taken into account, so that the FTT's decision was not strictly binding on that. And there's been no appeal from the judge's decision below that the first tier tribunal's decision was not binding. I mean,
It's not binding, but it's a decision. Then you've got the original refusal. Then you've got the maintained decision, which doesn't refer to anything to do with this. Then you say you're going to look at the application.
yes.
And it's pointless because you granted limited leave when you didn't look at the application properly on this hypothesis, and she's stuck.
Well, looking at the point in principle, if someone has leave to remain or leave to enter under Appendix FM, we submit that it must be that is a relevant consideration when applying 2971F. The way that works in this case is that on reflection in the light of that argument, we do say that the reconsideration was bound to fail.
What is the question that has to be asked and answered under 2971F?
Well, whether there are serious and compelling family or other considerations which make exclusion of the child undesirable.
And is your answer to that question we're not going to exclude her. She's got leave to remain.
That's the second submission. At this stage, I'm assuming that the test has purchased because you adopt, as my lord.
The hypothesis.
Exactly,
If she were to be excluded, would that be undesirable?
Yes, and
And so how is her immigration status relevant to that question? Because the question being posed at this limb of the analysis is, if she were to be excluded, would that be undesirable? So what's her immigration status got to do with that? The hypothesis is she's being excluded.
well, the submission is that it must be part of the overall factual matrix that a decision maker has.
What fact? How do you take into facts which are contrary to the statutory hypothesis that you are required, which poses the question that you are required to answer? You can't have a fact which contradicts it.
Well,
It's not relevant to the question that's being posed. I see the argument which says, well, the question doesn't arise because we're not excluding her, but that runs into problems with AB Jamaica and all those cases.
yes, and that is a separate point that I'll come to. The immigration status of the applicant is relevant, at least insofar as it indicates something like the duration of exclusion, which would be relevant to the circumstances. Applying the words in the immigration law.
I think you and Mr. Lewis agree about what the question is.
Yes.
He puts it in paragraph 20 of his skeleton argument, which we have at page 11. Can we just check that we're secure in that understanding? I understand your submission to go to what happens next in answering the question.
Yeah, so the submission I'm on at the moment assumes that approach is broadly correct.
No, it's not an assumption. You've just told us you agree, and I just want to make sure that you.
The
you agree is the question that I understood you to agree with my lord a moment ago was appropriate, was whether if X were done, it would be undesirable. Frankly, seems to me to be
Yes.
very obvious that that is the question, but I just want to understand where it seems obvious to you as well.
Yes, my lord. That's right. That's right. So when assessing undesirableness, if you like, the immigration status of the applicant we say is a relevant consideration. I take on board my lord's point that looking at the way the question is framed, it might seem that immigration status is the very matter in issue and so falls to be excluded. I would submit that is an artificial approach which the court should not adopt. At the very least, the immigration status of the applicant is relevant to the duration of the exclusion, and with great respect, on a common sense approach and a purposive approach to these provisions, it would be surprising if an entitlement to be in the United Kingdom were excluded as irrelevant.
The problem is this: the rule presupposes indefinite leave to enter. The only reason we've got to the situation is because you said no. You can't rely on 297, you can only rely on FM and therefore you get limited leave. If you're wrong on that, you should always have granted her indefinite leave because it was always obvious that she shouldn't be left with her grandmother in Ivory Coast. And it's rather odd then, that's what I'm struggling with, it's rather odd to say, well, I know none of that should have happened, and I know we agreed to reconsider the application, and I know the question is, if she were excluded, would that be undesirable? But nonetheless, in some way that I haven't fully cottoned on to yet, the fact that a mistake has been made and she was given something that wasn't what she applied for and shouldn't have been granted, in some way is the answer to deciding what she did apply for and what, on this analysis, she should have been granted. That's the problem that I've got.
Yes. Well, even going back to the 2009 decision, at that time, the mother did have leave to enter or remain under Appendix FM. And so even at that stage, the decision maker could have concluded that the...
But no, that's the whole point. This is if you've lost everything else.
Yes.
You've lost ground one, and she can just apply as she did for one parent only. And if you've lost that, the next thing is it's got to be,
Yes.
would it be awful if you were excluded?
Yes. If you look at this hypothetically on the assumption that the applicant is outside the United Kingdom and doesn't have leave to remain, then plainly you would exclude the fact that she is entitled to leave to remain or has leave to remain. But that's not the way that the decision making in this case was undertaken. Largely because of the unusual circumstances here, where there was a reconsideration in 2023 of a decision that was taken years earlier. So if I'm right that at the stage of reconsideration, the decision maker was entitled to have regard to the fact that the respondent was granted leave to remain, then you do get resubmit to a situation where you should take that into account, that entitlement or grant of leave.
You said a moment ago that even assuming that the question is as Mr. Lewis says it is, and which you agreed, the grant of limited leave to enter was relevant to the duration of the exclusion.
At the very least, it would be relevant to
But I don't quite follow that, because the whole point of the limited leave is she's not excluded and won't be excluded unless and until that limited leave expires. So how can that bear on the duration of the exclusion at the moment when the decision maker is making the decision? I simply don't follow that.
What it means is that she can come into the United Kingdom immediately.
That's the same point. You're saying that because factually something can happen, she never has to leave. That answers the question of if she were excluded. It's the same thing, really. The duration doesn't add anything.
Well, I think that there are 2 points. There's a duration point. I hear what my lord says. And there's the point about purpose and sensible interpretation, going back to the language used in the HAD. We submit that adopting that approach to the interpretation of the rule, the decision maker should take into account an entitlement to leave, because that's just a naturally relevant factor when it comes to the exercise of immigration control. And the submission is that approach is consistent with the cases under section 117b6. I've given you the reference to Runa at paragraph 36 and paragraph 44. At paragraph 39 of my skeleton argument. Can we just briefly look at that? That's behind tab 6, beginning at page 117, page 126.
Sorry, are you in the core bundle now?
I'm so sorry, this is the authorities bundle.
Right. And page, sorry, I've now lost the page.
So it's paragraphs 36 and 44.
On what page?
Okay,
I haven't
so
got tabs.
36 is on 126 behind tab 6.
Yeah, we haven't got tabs.
I'm so sorry, so it's 126.
Yeah.
So you'll see in the second sentence of paragraph 36 that the court accepted my alternative submission in that case, that the primary submission was that because you adopt a hypothetical approach, you exclude, you can see this at paragraph 34 and following, you
This is another
This is
117B.
117B. Yeah. This is the application of the test in AB.
So what's the question? Rather than taking a paragraph out of context, what's the question, first of all, and what are the facts that are said to be relevant to that question? Because we need to know that in order to see whether these words in abstract help.
Yes. The grounds of appeal are at paragraph 14.
1.4.
Paragraph 1.4, yes. Page 122. And the submissions in respect to those grounds are then summarised in 15 and 16. And
So the question was it reasonable to expect the child to follow the parent? That was the question that the
yes.
Upper Tribunal posed itself.
Yeah.
Right.
And what was your primary submission? Where do we find that?
So we see that at paragraph 15.
So 24 is where your submission is summarised, is it?
Thank you, my lord. Yes, page 124. That's the primary submission that was rejected at paragraph 36.
So we're dealing with a case where one parent is a British citizen and the other parent has no right to remain.
Yes.
And your primary submission is it can never be reasonable to expect the child to follow the parent with no right to remain. That seems to be it. Is that it? A categorical approach.
Yes.
And your alternative is, if you're asking the question, is it reasonable to expect the child to follow the parent with no right to remain, you must find the facts before you can answer the question.
That's right.
But you're not, the submission you make in Runa doesn't say you must assume the child won't leave. You still assume the child will leave, but all you're asking is that reasonable?
Yes, and when you assess reasonableness, what the court held at paragraph 36 is that the provision calls for a fact-finding exercise so
Yes,
that the full
certainly.
factual background must be established.
Certainly. But still the question is, on the assumption that the child is going to leave, is that reasonable? Would
Yes.
it be reasonable? So that doesn't get you out of the bind, as I see it. The question under Rule 297F is, if the child were to be excluded, would that be undesirable?
Yes. So the submission is that the immigration status of the child is a relevant consideration when it comes to that assessment. And I appreciate my lord may not be with me on that. Paragraph 44 is the other passage that's relevant.
Well, you start to get it at 41 because we're trying to work out what facts you're talking about. And there were two possibilities, it seems. One, that the whole family would go, so there'd never be a breakup.
Yes.
And the other is that the children would stay with the British citizen father, but would lose access to their mother, that she would go.
Yes.
So that was the question. Was that the factual question, what would happen if?
Yes. So
If you hadn't asked what would happen if.
yeah, that's right. And the wrong test was applied by the Upper Tribunal. They applied a
It's a multiple obstacles test, but that's a different thing.
it's a different point.
But the facts for the purposes of this case that you'd have to ask, because you would ask whether it's reasonable to expect the child to leave, you've got to ask, well, what will happen?
Yes.
Will they stay with the mother and with the father only, or will they all have to go?
Yes, and the submission that because of the way that 117b6 operates in this sort of fixed hypothetical fashion. You just assume that the parent with the entitlement to stay will stay, so that you undertake the 117b6 assessment on the basis of a family split. That submission was rejected, and the alternative submission that you look at all the circumstances was accepted. Paragraph 44 on page 128, the court acknowledged that the immigration status of the parents would be a relevant consideration. See just above line marking C.
Well, of course, because the question is somebody going to leave? Not, is it desirable to exclude someone? So, of course, immigration status is relevant.
Well, in the AB case, the argument, and we can look at that briefly if you wish, it's behind tab 5. The relevant passages are paragraph 73 to 75 on page 107 to 108.
Yeah.
Tab 5, paragraph 73 to 75, page 107 to 108. In AB, it was held that even in a case where a child would not be removed as a matter of fact, the provision still applied.
Yes.
And we
So even if a child is not going to be excluded as a matter of fact,
yes,
the provision still applies.
yes. But the case did not involve a situation where there was a grant of some form of immigration status.
No.
But isn't that case against you, though?
It's against me, or well, assuming you accept the analogy between the statutory language in 117b6 and 2971F, it's against me on the second submission, which, if I may, I'll come to now, unless there are any further questions on the first. I mean, I accept that it's a narrow and straightforward question. Is immigration status of an applicant relying on 2971F a relevant consideration, bearing in mind the statutory test? You have my submissions.
Yeah.
Those 2 points, it's at least relevant to duration, just as a matter of logic, duration of exclusion. And in any event, adopting a sensible purposive approach, it should be taken into account because it's relevant to the overall exercise of immigration controls. The second point we make, this is paragraph 41 and following of my skeleton argument, is that the Upper Tribunal was wrong to reject the submission that it was necessary to undertake a counterfactual assessment applying the wording of 2971F. And the submission is that set out at paragraph 42. Although it's clear that the word undesirable has a normative meaning, the words exclusion of the child are not normative, they are factual. And essentially what they are assuming is the natural counterfactual, they're assuming the natural counterfactual in the event the application is refused. But if, on the facts of a given case, the facts are that the person will not be excluded, then that counterfactual assessment, the assumed the exclusion, will not be the case, and the rule should not apply. Now, against me, my learned friend relies upon an analogy with 117b6, which the court, of course, appreciates. But the statutory wording in section 117b6 is materially different in my submission from that in paragraph 2971F. I'm afraid we only have the text of the statute in the judgment in AB, which is again behind tab 5, page 103. At paragraph 47, this court sets out the terms of section 117b, and its subsection 6, my learned friend says, is analogous, and the Upper Tribunal held was analogous.
Paragraph 42.
Oh yes, with my
Your skeleton argument.
my replacement skeleton argument.
42.
Yes.
understand the paragraph. At the moment, it doesn't seem to. The sentence doesn't seem to work. Just give you a moment to think about it, because are you seeking in your second point to go back on the agreement which we thought we had a moment ago about what the question is? Isn't that what this is about?
I accept what the question is because that's clear on the face of the immigration rule.
Yes.
The
Isn't this seeking to ask a different question? At the moment, it doesn't seem to either have a verb or a final clause or whatever it is. It just doesn't. At the moment, I can't understand the point that is made in paragraph 42.
Well,
Simply because of its grammar.
very well. Well,
What's missing?
the submission is that although the word undesirable clearly has a normative meaning, the words exclusion of the child refer to the counterfactual denial of entry to the UK. And so if that's right, if there will be no denial of entry to the UK, then the rule cannot be met.
The question is, if there were denial, not will there be denial of entry, and that reflects the fact that the starting point is you're outside trying to get in. And the question is, if you were to be outside the UK rather than in the UK, would that be undesirable?
Isn't your submission exactly the same as Miss Patrick's submission in AB Jamaica? Essentially to say, well, we're not going to exclude the child, so the question doesn't arise. We don't need to answer it.
That's the point. So yes, there's a single test.
Yeah,
but
that's what this court rejected in AB Jamaica.
Indeed. So I accept that if my court accepts the analogy between this provision and 117b6, and my learned friend relies upon and the Upper Tribunal relied upon and accepted, we'll lose on this submission.
Yeah.
And I was just in the process, so I was just dealing with my Lord Justice.
But I'm understanding, I mean, I can see that in the first line of the second page of that paragraph, there is it must mean that the test is something or other that we apply a counterfactual. I can see that there be some redrafting of that, but it strikes me that this is just another way of disagreeing with what you just agreed with a moment ago as to what the question is.
Well, I think it's more about how the question falls to be answered. Unlike in 117b6 cases, the question in respect of 2971F is answered simply by concluding on the facts that there will be no counterfactual denial of entry to the UK.
But if there were, would it be undesirable?
I mean, obviously, the way the question is put to me assumes that we're wrong on this approach. And again, we rely on a sensible, purposive interpretation of the rule, but we also rely on because the reality is, if there's not going to be any issue about whether the applicant for indefinite leave is able to stay in the UK, that they don't need to rely upon this provision, and it should be open to decision makers to apply a common sense approach in those circumstances. But we also rely on the language of the rule as being importantly distinct from that in 117b6, and this was the point that I was just coming to. So if we go to the AB Jamaica case, where you'll find section 117b6 set out, it's on page 103 behind tab 5. Now, section 117b is a piece of primary legislation that identifies certain factors and certain particular questions that are relevant, that must be considered in every case when it comes to immigration decision making in respect of Article 8 of the ECHR. Sub 6 deals with children, and it sets out a, if you like, categorical rule in respect of where the public interest lies. The public interest does not require the person's removal where, and then you have the statutory condition, person has a genuine and subsisting parental relationship with a qualifying child, and this is the key part of the rule, subsection, it would not be reasonable to expect the child to leave the United Kingdom. Now, it's the words "to expect the child to leave," and in particular the words "to expect," that were central to this court's analysis in AB. We see that at paragraphs 73 to 75 that we looked at briefly earlier, bottom of page 107. At paragraph 73, there's a memorable analogy or reference to what Admiral Nelson reputedly said or expressed during the Battle of Trafalgar. England expects every man to do his duty. What Lord Justice Singh, with whom the other members of the court was saying there, with whom the other members of the court agreed, was saying there, is that the word expects has a normative and not simply a factual meaning. It was acknowledged that there was a degree of ambiguity in the expression. If you look at the top of page 108, in my view, the concept of "to expect" something can be ambiguous. It can be, as the Upper Tribunal thought, simply a prediction of a future event. However, it can have a more normative aspect, and the court went on to conclude that it was the normative meaning of the expression "to expect" that was applicable. But if we go back to the language of 2971F that's relevant in this case.
Sorry, just before we leave paragraph 73,
Yes.
what Lord Justice Singh says, bottom of page 107, is that what the UT said about expect doesn't make any material difference to the ultimate interpretation, which I consider was correctly set out by the UT in JG. And if you go back to what the UT said in JG, you find it at paragraph 66, page 106. As a matter of ordinary language, the question, would it be reasonable to do X, presupposes the doing of X. It's unlikely to be an appropriate or helpful response to refuse to answer it on the basis that one does not intend to do X. That's what the UT decided in JG.
Very well.
And that's what's endorsed by this court in AB Jamaica.
Very well. And if my lords conclude that the same structure is apparent in the statutory, in the test in 2971F, then we will lose on this submission. At the moment, I'm simply pointing to what we submit is an important distinction between the language in 117B6 and 2971F. 2971F does not use the word "to expect," the words "to expect," or anything that can be construed in normative and not factual terms in its place. At paragraph 42 of the skeleton argument, we fix on the words "exclusion of the child," in contrast to the words "to expect" in 117B6, and submit that the words "exclusion of the child" are referring to the counterfactual denial of entry to the UK. So that although the statutory test is still available, if the circumstances on the facts are that there will be no counterfactual denial of entry to the UK because the relevant applicant has an entitlement to come to the UK and is indeed in the UK, as is the case here, then we submit, adopting the approach in Mahad and Wang, with respect common sense, sensible, purposive interpretation of the relevant rules in context, that should be a determinative factor that shows that the test in 1971F is not met. Those are the submissions, my lords. Can I just turn my back? Thank you very much for my lord's indulgence. I've got nothing.
Yes, thank you very much. We will rise for a couple of minutes. Don't leave the courtroom just to see where we go from here.
Court rise if able.
Let me explain. Thank you so much.
Rise if able.
We will adjourn now till 2 o'clock, and at 2 o'clock, Mr. Lewis, we would like to hear you on ground 3, in particular the significance or otherwise of Rule 301. We needn't trouble you on the remaining grounds unless there is something that you particularly want to draw to our attention.
My lord, I don't think there will be, but that's very helpful.
Right, 2 o'clock.
Court rise if able.